Hello everyone, and welcome back to the Spanish Sling, a podcast where we try to bridge the gap between the Spanish and Singaporean companies and encourage economic relations between them. Throughout the interviews, we have tried to help different companies, both Spanish and Singaporean, to understand the sector in Singapore and Spain and its opportunities. But sometimes disputes may arise between companies, and they may not be so aware to different procedures they can follow. So this is why today we welcome to the Spanish Sling Jana Lamas. Jana, welcome to the Spanish Sling.
Thank you, Clara.
So to give you a little bit of your background, Jana is a senior associate at Uría Menéndez, who is a Spanish law firm. But now you're in Singapore, and that's why you're here. So you're a visiting lawyer at a Singaporean law firm called Allen Gledhill. So you have an understanding of both backgrounds, so the both legal backgrounds in Singapore and in Spain.
Exactly.
And you also understand the different ways of having an alternative dispute resolution.
Yes.
So during this first part of the interview, we're going to talk about alternative dispute resolution. So you have a legal background, and I'm sure that the viewers also can have like maybe lawyers, or they may be also having a Spanish or Singaporean legal background. But for those who are not familiar with the terms, so can you explain what alternative dispute resolution means and what are the benefits?
Yes, of course. So when parties to a contract run into disagreement regarding a point of law or of fact as to the performance of the contract, then we can say we have a commercial dispute between the parties. When they cannot resolve these disputes through negotiation or in amicable terms, then they would take the dispute to court. Or that is what many people would think. Going to court is the default option, and many companies would stick to it simply because they don't know of the alternatives. However, there is a wide range of alternatives for parties to get their dispute settled. And this is what we call the alternative dispute resolution mechanisms. And they are varied, but as I said, not all the contracting parties or companies know about them, so they don't put it in the contract.
Exactly, because I think the traditional way that everyone thinks, maybe even because of the movies, that we just go straight to court. But there are different ways. So, Jana, what are the different alternatives for dispute resolution?
So I would say for international transactions, the main ADR, how it is known by the initials, is our mediation and arbitration. They have different characteristics, and depending on what type of dispute or what are the intentions and objectives of the parties, I would recommend one or the other. In mediation, first of all, parties would try to reach a mutually acceptable settlement to the dispute. They would use the assistance of a mediator, one or more mediators. And I would say mediation is a less confrontational ADR mechanism, because when parties go to mediation, they try to preserve the relationship. So they don't want the dispute to escalate to arbitration or to litigation before courts. And the mediator is actually not adjudicating the case, but is helping the parties to negotiate and reach agreements in a constructive manner. So the parties are also involved in the decision making, so they have control over the outcome. And sometimes they come up with a settlement which is more longer lasting, or which brings more greater satisfactions to the parties. So that's certainly very valuable when you want to preserve the contractual relationship. And then you have arbitration. Arbitration is pure confrontational litigation, let's put it that way, and that's when parties submit their dispute to a third and neutral body, which is composed by one or more arbitrators. The arbitrators are appointed by the parties and renders a final decision on the case, which is binding on the parties, so they have to comply with the decision.
Exactly, really interesting. So we have, the top will be the court, the traditional court, and the arbitration with the arbitrators and the judge. Exactly. And then we have a friendly way that it's called mediation.
Yeah.
And I think maybe not many people are not so familiar with that. So it's kind of the first step in a way, and it's even more amicable.
Yeah, exactly. And we are we're starting to see it's becoming more and more frequent to see mixed formulas between arbitration and mediation, or well, the other way around, mediation first and then arbitration, or mediation or court litigation. So even the arbitration institutions encourage companies to try to reach an amicable settlement before going to full litigation, which is longer, it takes longer and it's more expensive.
Exactly. So I have heard like long, expensive, but what are the advantages of choosing arbitration over the traditional court?
So arbitration is the most preferred ADR mechanism for international companies involved in international transactions. So the reasons are mainly because the parties can decide on how the dispute is going to be resolved. Mm-hmm. So the parties can agree on the procedure, they can set out the rules of evidence that will apply to their proceedings, they can decide on the timing. So if they want an expedited procedure, they want the decision to get rendered fast, then they can agree on like very short timings. They can decide on the language of the proceedings, which is certainly a very valuable feature, considering like in international transactions, if you're doing business in Vietnam, you don't speak Vietnamese, so you would rather go through English proceedings. And those are, well, also like proceedings are usually confidential, so is the final decision. Mm-hmm. So that's something that gives a lot of comfort to international companies as well. And these are all characteristics which you cannot find in domestic courts, because in court proceedings, the procedural rules are non-consensual. They're set out in laws. Parties have no control over the timings, and usually these proceedings take years and years. And also they are publicly available, so they are not confidential. And then the judgments that are rendered are not as easily enforceable in other jurisdictions. Mm-hmm. as awards coming from arbitration. Mm-hmm. are. So all those are really like characteristics which appeal to international
and great advantages as well. So we have this flexibility which we wouldn't be able to find in the traditional courts.
Yeah, correct.
And the privacy as well that you have mentioned. But what are the disadvantages? Because I'm sure that they have to be.
Yeah, well, I already mentioned some. So cost for me, or well, for companies is the biggest concern, I'd say, because in general, like court only charge court fees, mm-hmm. which are lower than arbitration or institutional arbitration fees. And also sometimes arbitration, because of the complexity of the dispute, may take or require more work, because the procedure allows the parties to engage in the defense in depth, and that renders a lot of costs. So, and also another disadvantages that I can think of is that the powers of the arbitrators are limited. So they cannot they can render orders directed to other parties, mm-hmm. to third parties, to the dispute, but they are not. These third parties have not may not abide by these orders, because they are not part to the arbitration agreement. They are not part to the contract. So that's something that does not happen with court. Court can issue an interim measure, and the party that is requested to comply with it must comply with it.
Exactly. Well, so I mean, of course, in any dispute there will be some the procedures. There will be advantages and disadvantages that the parties have to ponder and choose whether to follow a traditional mechanism like court, or the alternative dispute resolution that you have mentioned. So to conclude, Jana, do you think there's this kind of alternative dispute resolution that you have mentioned, so mediation, arbitration, they will become even more prevalent than it's nowadays in the future?
So I think arbitration is here to stay. You just need to look at the data. It's the most preferred mechanism. So, and it really meets the demands of international businesses. So it will stay. I think it may become stronger, or certain practices may become more trendy than others, but what I think is more important is that companies pay or are aware that there are other mechanisms that they can resort to as opposed to court litigation, and that starts with just being aware of these options when they draft their contracts. And on the other hand, we have mediation. Mediation, we still need to wait and see, but I think mediation has a bigger role in the future, because in international transactions, I think companies are starting to realize that mediation is actually a very viable way to resolve the disputes.
Exactly. So thank you so much, Jana, for giving this excellent overview
Thank you.
of the alternative dispute resolution, and of course to make the companies understand that they have different options, which I think is great, in order to solve disputes in a friendlier way, as you say, or even in a more flexible way.
Exactly.
So thank you very much for coming.
Thank you.
Thank you.